Good day everyone. I am Alim Maridel from PCBet 01402A and my report is about Section 3 Classes of Corporations. So maraming klase ang corporation, pero mas una nating i-discuss yung dalawa sa pinakakilalang klase ng corporation. So first is stock corporation. What is a stock corporation? It is a corporations which have capital stock divided into shares and are authorized to distribute to the holders of such shares dividends or allotments of the surplus profits on the basis of shares held. At dapat tandaan na ang stock corporation is also an ordinary business corporation created and operated for the purpose of making profit, which may be distributed in the form of dividends to stockholders on the basis of their invested capital. Next ay ang NonStock Corporation. So ano nga ba ang NonStock Corporation? A non-stock corporation is one where no part of its income is distributable as dividends to its members, trustees, or officers. Also, a non-stock corporation is a corporation which do not issue stock and are created not for profit but for the public good and welfare. Usually, ang mga non-stock corporation ay yung mga religious, charitable, social, literary, scientific, civic, and political organizations and societies. Ang non-stock corporations may make profits, but the profits are not distributed to the members kasi meron silang sariling funds, and the onset there are contributions from the members. Ang example ng non-stock corporation ay ang St. Luke's Medical Center. It is organized as a non-stock and non-profit charitable institution. So next nating tatalakayin ay ang Government-Owned or Controlled Corporation or GOCC. A GOCC is any agency organized as a stock or non-stock corporation vested with functions relating to public need, whether governmental or proprietary in nature, and owned by the government directly or through its instrumentalities, either wholly or where applicable as in the case of stock corporations, to the extent of at least 51% of its capital stock. Note that hindi dahil government-owned siya, wala ng stock. Meron po. Pwede siyang stock, pwede ding non-stock. Kung stock corporation siya, para malaman mo, dapat owned siya ng gobyerno, at least 51 ng capital stock. Ang example ng government-owned, controlled corporation organized as stock corporations. Congress has created through special charters several government-owned corporations organized as stock corporations. Prime examples are the Land Bank of the Philippines and the Developmental Bank of the Philippines. Other government-owned corporations organized as stock corporations under their special charters are the Philippine Crop Insurance Corporation, Philippine International Trading Corporation, and the Philippine National Bank before it was recognized as a stock corporation under the Corporation Code. So, meron ding example kung paano i-recognize ang isang company na or corporations kung government-owned ba siya. Merong sample sa book ng isang case which is in Manila International Airport Authority versus Court of Appeals. So, tinatanong dito kung ang Manila International Airport Authority ba ay stock or non-stock corporation. And the court made a distinction between a government-owned or controlled corporation and an instrumentality. So, sabi sa meaning ng government-owned or controlled corporation, it must be organized as a stock or non-stock corporation. Pero ang Manila International Airport Authority is not organized as a stock or non-stock corporation. Ang MIAA or Manila International Airport Authority ay hindi stock kasi wala siyang capital stock na divided into shares at wala siyang stockholders or voting shares. And again, ang meaning ng stock corporation is capital stock divided into shares and is authorized to contribute to the holders of such shares dividends. So, ang MIAA has capital, but it is not divided into shares of stock. And MIAA also has no stockholders or voting shares. Hence, MIAA is not a stock corporation. Manila International Airport Authority is also not a non-stock corporation because it has no members. According to Section 86 of Revised Corporation Code, defines non-stock corporation as one where no part of its income is distributable dividend to its members, trustees, or officers. So a non-stock corporation must have members. Even if we assume that the government is considered as the sole member of Manila International Airport Authority, this will not make MIAA a non-stock corporation, because non-stock corporations cannot distribute any part of the income to their members. And according to Section 11 of the MIAA Charter, mandates to remit 20% of its annual gross operating income to the National Treasury. This prevents MIAA from qualifying as a non-stock corporation. Since MIAA is neither a stock or non-stock corporation, MIAA does not qualify as a government-owned or controlled corporation. So, yun yung isang case na sinuri nila kung yung Manila or naging case siya na umabot sa Court of Appeals na tinatalakay nila kung ang Manila International Airport ba ay stock or non-stock corporation. At ang lumabas, hindi siya non-stock at hindi rin siya stock. So, ibig sabihin, hindi rin siya qualified sa government-owned or controlled corporation. So, yon. Next. So, bukod sa stock at non-stock corporation, sinabi ko kanina na marami pang classes ang corporation. Isa na dito ang as to purpose ay ang public corporation and private corporation. So, a public corporation is a corporation organized for the government of a portion of the state for the general good and welfare, while private corporation is a corporation formed for some private purpose, benefit, or end. Ang public corporation is ito yung corporations created for political purposes. Example neto, mga LGU or mga iba pang local governments na pwede siyang general law or special law. While private corporation, nakasaad sa Section 16, Article 12 na pinagbabawal ng Constitution na bumuo ng private corporation through special law. And mamaya, mas tatalakayin pa natin kung bakit bawal bumuo ng private corporation through special law. So next is na under ng as to purpose is government-owned or controlled corporation, which is diniscuss natin sa last or past pages ng report. So, yun, na-discuss na natin yung government-owned or controlled corporation. So, next natin is yung quasi-public corporation. A private corporation which has accepted from the state the grant of franchise or contract involving the performance of public duties but which is organized for profit. It is also engaged in a private business involving public interest, like mga public utility companies. Example neto is Meralco, tsaka PLDT. Kasi karaniwan nito ay public utilities nga. Kasi it is created by operation of general corporation law but performs governmental functions. Yan. And next is, under ng as to legal right to corporate existence is ang de jure corporation or de jure corporation. A corporation created in strict or substantial conformity with the mandatory requirements for incorporation and the right of which to exist as a corporation cannot be successfully attacked or questioned by any party even in a direct proceeding for the purpose by the state. So, to be considered de jure, the company must have fulfilled all the requirements for properly forming a corporation. While de facto corporation means the due incorporation of any corporation claiming in good faith to be a corporation under this code, and its to exercise corporate power shall not be inquired into collaterally in any private suit to which such corporation may be a party. Such inquiry may be made by the Solicitor General in a co-warrant proceeding. So, it is a one which exists for all practical purposes as a corporation, but which has no legal right to corporate. So, ang de facto is, ang requisite niya ay it is organized by valid law and attempt in good faith to form a corporation to the requirements of the law. And lastly, use of corporate powers. So, dapat nag-i-exist na siya kasi meron ng use of corporate powers. Pero, naging de facto siya, ang de facto is meron na siyang colorable compliance with the requirements of the law. So, kaya siya naging de facto is baka nagkaroon ng problema yung isa sa mga requirements or papeles na ipapasa nila. So, yon. Kaya, dahil nagkaroon ng defect or nagka-problema, kaya siya naging de facto at hindi siya makapag-exist kasi kulang yung requirements niya. So, yon. Next is corporation by estupel. All persons who assume to act as a corporation, knowing it to be without authority to do so, shall be liable as a general partners for all debts, liabilities, and damages incurred or arising as a result thereof. Ibig sabihin, neto, wala siyang real existence in law. Neither de jure or de jure, correct me if I'm wrong, or de facto. Also, a mere fiction existing for the particular case and vanishing where the element of estoppel is absent. So, lastly is corporation by prescription. It is one which has exercised corporate powers for an indefinite period without interference on the part of the government. Kung wala ang general corporation law or a special incorporation law, corporations cannot exist in the eye of the law. But corporation by prescription is the exception. Yon. Next is as to laws of incorporations, which naka-under sa kanya yung domestic corporation and foreign corporation. So, ang domestic corporation means a corporation incorporated under the laws of the Philippines. So, dito lang siya sa domestic area or dito lang sa Pilipinas. While foreign corporation is a corporation or a corporation is formed, organized, or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporation to do business in its own country or state. Next is as to whether they are open to public or not. So, ang naka-under sa kanya is open corporation and closed corporation. An open corporation is a corporation which is open to any person who may wish to become a stockholder or member thereto. So, ibig sabihin ng open corporation, open siya sa lahat. Basta gusto nila, ganon. While closed corporation is one whose articles of incorporation provide that, first, all the corporations issued stock of all classes, exclusive of treasury shares, shall be held of record by not more than a specified number of persons, not exceeding 20. Second, all the issued stock of all classes shall be subject to one or more specified restrictions on transfer. And lastly, the corporation shall not list in any stock exchange or make any public offering of any of its stock of any class. Okay, next is as the relationship of management and control. Naka-under dito ang parent or holding corporation tsaka subsidiary corporation. A parent or holding corporation means a corporation that holds stocks in another corporation for the purpose of control, while a subsidiary corporation, a corporation more than 50% of the voting stock of which is controlled directly or indirectly by another corporation, which thereby becomes its parent corporation. Next is as to the number of persons who compose them. Naka-under ang corporation aggregate and corporation sole. Corporation aggregate means a corporation consisting of more than one member, while a corporation sole is a corporation consisting of only one member for the purpose of administering and managing as trustee the affairs, property, and temporalities of any religious denomination, sect, or church. Next is as to whether they are for religious purposes or not. Under niya ang ecclesiastical corporation and lay corporation. An ecclesiastical corporation is a corporation organized for religious purposes, while lay corporation is a corporation organized for a purpose other than religious or religion. Lastly is as to whether they are for religious no. Lastly, typo. As to whether they are for charitable purposes or not. Under neto yung eleemosynary corporation and civil corporation. Eleemosynary corporation is a corporation organized for charitable purposes, while a civil corporation is an organization or a corporation organized for business or profit. So, that's all for the Section 3 classes of corporation. So, let's go to the next topic, which is Section 4, corporations created by special laws or charters. A general law versus special law. So dito, i-explain natin kung anong pinagkaiba ng general law sa special law. So, a general law under which a private corporation may be formed or organized is the corporation code, while a special law shall be governed primarily by the provisions of the special law or charter creating them or applicable to them. It is also government-owned or controlled corporation may be created or established by special law. So, according to Section 16, Article 12, na pinagbabawal ng Constitution ang pagbuo ng isang private corporations through special law. Ang Revised Corporation Code, ang covered neto or saklaw nito ang private corporations. So, ibig sabihin, lahat ng private corporations ay under nito. At dahil ang Revised Corporation Code is general law. So, sabi doon sa Section 16, Article 12, the Congress shall not, except by general law, provide for the formulation, organization, or regulation of private corporations. So, kaya pinatupad ang Revised Corporation Code ay para magkaroon ng private corporations. So, that's all for my report. Thank you.